We will start for the SAP calendar for Thursday, March the 12th, 2026. And is it Mr. Wade? Is he a private counsel for someone?
Good morning, Your Honor.
Good morning.
Yes, Addison Wade.
Addison Wade.
I'm position number 43 at the court's pleasure.
Okay, thank you.
Thank you.
Good morning. How you doing?
Good morning.
I'm going to start off with number 42, Mr. Taylor.
Number 42, did you say?
Yes, ma'am.
Okay.
Your Honor, that would be a negotiated plea.
All right, this is 26 CR 001275. Terrius Taylor, charged at 1 count of simple battery. State.
Yes, Judge. Due to her pending felony, I don't believe she's gonna have any time out to do anything on probation. So the offer is to plead guilty to simple battery with the terms 12 months to serve 34 days, credit for time served 17 days, balance suspended with no further contact with Tierra Lamb.
And Your
All
Honor,
right, PD Haddad.
we stipulate for purposes of the plea, Judge, as to identity, venue, and factual basis, Judge. We ask the court to follow the state's the negotiated plea.
All right. Miss Taylor, can you raise your right hand for me? I understand you wish to plead guilty. Is that correct?
I don't even know what case he's dealing with.
Your Honor, it's Mr. Taylor. I'm sorry.
I'm sorry, Mr.
I don't know
Okay.
to get it over with and not have some.
That wasn't my question. My question is, do you wish to plead guilty? Yes or no?
Yes, so I don't even know what case this is. I don't know the person. I don't know her. Yeah, about to
What, Your Honor, I went and spoke to him yesterday. I mean, if he wants to take a plea, that's fine. If he wants to try,
I plead guilty. I ain't trying to take no plea. I'm pleading guilty. Just to get it over. Yes.
All right. I need to make sure that you understand what you're doing and that your plea is free and voluntary. So you would have to abide by these conditions if you take this plea today. Are you willing to do that?
What's the conditions? Yes, but yes.
Did you just hear the state say what the conditions were? No further contact with Tierra Lamb.
But yes, okay, yes.
I'm sorry?
Yes, yes.
All right, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, you have to say yes so the court reporter can record your responses. Put your hand down for me. I'm going to ask you a series of questions to make sure that you understand what you're doing. The first question I have is, are you presently under the influence of any medication, unprescribed medication, alcohol, or drugs that would hinder your understanding today?
No.
Are you satisfied with the services and representation of your attorney?
Yeah. Yes.
Okay. And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer? And you are prepared and agree to waive these rights today, is that correct?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone told you that, I'm sorry, has anyone promised you anything to plead guilty?
No.
And you do understand that if you're currently on probation, it could be affected by this guilty plea today.
There ain't no probation.
Okay, so if you're not, okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
All right, and so I told you what the conditions were, and good luck to you. And I will accept your plea of guilty to 1 count of simple battery.
Thank you, Judge.
All right.
All right, then we got 46 and 45, 46, Mr. White.
Okay.
Likewise, Judge, that's gonna be a negotiated plea.
All right. I have 25 CR 000267K. Aldwin White, charge of 1 count of theft by shoplifting. Have a second case is the FTA 26 FTA 000453.
Yes, Judge. Mr. White is pleading guilty to theft by shoplifting with the terms 12 months to serve 30 days, credit for time served 10 days, balance probated, to complete the anti-theft course, pay a $500 fine, and to stay away from the Walmart at 844 Cleveland Ave in East Point. In consideration of his plea, the failure to appear charge will be null prost.
All right.
I'm not the person that's going
Your Honor, we stipulate for purpose of the plea.
Right. All right, Mr. White, I understand that you wish to plead guilty. Is that correct today? Can't hear you.
Yes, ma'am.
Okay, I'm going to swear you in first, and then I'll ask you a series of questions, all right?
Yes, ma'am.
All right, raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder or impair your understanding of the proceedings today? Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am. Did they even ask me?
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, I am, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, yeah.
Has anyone promised you anything to plead guilty?
No, yeah.
And do you understand that if you're currently on probation, it could be affected by this guilty plea today?
Ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, I do.
And so as to the charge of theft by shoplifting, how do you plead?
Plead guilty, Your Honor.
All right, I will accept your guilty plea. You've heard the terms and conditions offered by the state. And that will conclude this plea. Yes?
Thank you, Your Honor.
All right, you're welcome.
Front row for the friend. I'm black. I'm a poor. Let's go for the Georgia law.
Are they gonna, just question, if y'all guys gonna address like probation, if I don't hear nothing, it's just on probation the whole entire time?
Every day I'm asleep down.
I just asking a question.
I would ask the state that.
Yes, Judge, on probation the entire time. No early termination.
Okay.
Okay, let's got one, this is 1, 2, and 3, Mr. Artisan.
Okay. Do you,
Your Honor, I believe that's Ms. McLeod's case.
and Deputy, are you aware that position 43 has a private counsel who's on the line?
I believe they took him downtown.
Uh-oh. Mr. James, is it Turcotte or Turcotte? Uh,
Yeah, they took
Attorney Wade, he's not there.
Oh man, they took him downtown, dude.
All right, so we're gonna reset this for when? Are you not sure?
Well, Your Honor, may I interject very quickly? A plea offer was made. I have not even had a chance to review discovery, so I wasn't able to, I can't in good conscience do that. We do have a consent bond to present to the court. I've already been able to communicate with Ms. Tucker regarding this, so whatever's easier on the court. But we did have a consent bond to present.
Okay,
Yes, this is position 43.
yes,
Okay,
ma'am.
yes. So it's my understanding that the only thing holding him is the FTA. So we are consenting to amend that to a $2,000 good bond.
okay. All right, and send that over to Miss Lewis. And then I'll sign that consent bond.
Do you want me to do that, Your Honor?
Yes. Well, I don't know. Is it the state doing the consent bond or is it private counsel? I don't know if he would.
I don't have the forms, but I'm happy to do it if I get a form to do it.
Yes, I have the form. I just haven't filled it out. So I will fill it out, send it to you to sign as well, and then send it to Judge Mincy to sign.
No, send it to
Yes,
me.
ma'am.
Send it to me.
Okay.
Yes, Ms. Lewis.
Send it to me. Don't send nothing to the judge. Everything comes through me to the judge. So please remember
That's
that.
what I meant by sending it to the judge. I meant by
Yeah.
sending it to you.
Yes, Ms. Lewis. Thank you.
You're welcome.
right.
I put my email in there, so in the chat.
Yes, ma'am.
My email. So once you sign it, whoever signed it, both of the signatures are on it, just send it to me.
Thank you, ma'am.
Thank
All right,
you.
thank you.
Judge, may I be excused after I send that bond order?
Yes, you may. Thank you so much.
Thank you, Judge. Good to see you.
All right,
Thank you, Ms.
too.
Tucker.
Yes.
All right. Good morning, Attorney McLeod.
Morning, Your Honor.
And I think we're going back now to positions 1 through 3. Is that Zakia Artister?
Yes, Your Honor.
All right. Is this a negotiated plea?
No, it's not, Your Honor. We would like the court to consider modification of his bond.
All right. Let me call the case. This is 26 CR 001323B as in boy. Charge at 1 count of battery family violence. And is it on all cases? The second case, 26 CR 001324 B. He's charged with fleeing or attempting to elude, reckless conduct, and reckless driving. And then the third case, 26 CR 001325 B. He's charged with simple battery family violence and a battery family violence. So those are the 3 cases that I have on the calendar for this morning.
Yes, Your Honor.
All right, State, go ahead.
Yes, Judge. I do not believe the bond should be modified. If it is modified, I think it should be raised. I originally argued this bond at SEA, and it was my requests were not given to me. So I would request it be raised. The arrest, this defendant has a felony fleeing and felony drugs, firearm by felon out of 2026. He has a pending aggravated assault strangulation against this same victim. 2025 25 SC 00059. He's got a theft by receiving felony and a firearm by felon that's open. 24 SC 000847. He has an ag assault and simple battery open. It is a different victim. 24, he's got a firearm by felon. In 2024, he has a battery family violence out of Clayton. In 2024, he has an aggravated assault and simple battery family violence. And they just go on and on. He's got 21 total cycles. So the facts in position 1, battery family violence, he punched the victim, Rodrika Abercrombie, who he has 2 daughters with, and dragged her through the grass, leaving scratches on her neck and a ripped t-shirt. In position 2, the fleeing, reckless conduct, and reckless driving, the officer observed a stolen vehicle that was flagged as possibly used in a homicide on the flock cameras. When they found the vehicle and followed him onto I-85, the officer attempted a traffic stop. He did not stop. He eventually exited the highway and parked and ran through a broken fence. His juvenile daughter was in the passenger seat the entire time he was fleeing. And that's the basis of the reckless conduct. And for the last position, position 3, another battery family violence against this same Rodrika Abercrombie. He was waiting for her at her apartment after she went to visit her mom for 2 days. He confronted her about a Twitter post saying it was none of her business and she was running her mouth too much. So he choked her. There were no injuries in this case. However, he has that pending aggravated assault strangulation against her as well. So he's got 3 open cases against this same victim, 2 open cases for firearm by felon, theft by receiving felony, aggravated assault, and simple battery family violence. And then the fleeing is in itself evidence of flight risk. And the fact that he did not care that his young juvenile daughter was in the car, he still fled through I-85 and left and got out the car and ran. I do not believe that the bond should be reduced.
And then tell me again, what's the current bond?
The current bond, one moment.
Okay.
It appears that it's 10,000 on each of the cases. So that's a total of 30,000.
Yes, and I had asked for 10,000 cash on each, but I believe 10,000 good was granted.
All right. Attorney McLeod?
Yes, Your Honor, the purpose of bond is to ensure that a defendant will show up for trial and any other proceedings that are set by the court. I didn't see that the state said that my client is in the habit of not showing up for court, Your Honor. He's in jail sitting on a bond that he just simply cannot afford. He tells me, Your Honor, that he missed his daughter's birthday and he's just been sitting here. I believe he told me that there's some issues going on with his mom, that he needs to get out of jail to address, Your Honor, but he just cannot afford this bond. So I am asking the court to consider lowering this bond to give him the opportunity to get out of jail so he can get out to properly defend against these charges. Just because allegations are made, that doesn't necessarily mean that the allegations are accurate, and he denies the accuracy of these allegations, Your Honor. As the court probably is well aware, sometimes people make outcries to police officers as a way of controlling their relationship, and it's not always the case that something has happened or that what they allege to the police is what actually occurred. So I think him sitting in jail doesn't help his case at all because he's not in a position to properly advocate for himself and to work with counsel to get an appropriate resolution of this case, Your Honor. He can help me to kind of investigate the case if he's on the outside. If he's in jail, I can't even properly share the discovery or anything with him.
And Judge, briefly, the purpose of bond is not just to ensure that he shows up. It's to ensure that the witnesses in the case are safe from him, that the community is safe, that he does show up, and that he's not at a risk of reoffense. His history, all of that history just in the past 2 or 3 years, he is a risk of reoffense. He is a risk to this victim specifically and to other victims. He has that pending aggravated assault and simple battery family violence against another person. When he is fleeing, not pulling over, he's got a felony fleeing. That puts everybody on the road at risk. And then he's a very high risk to Rodrika Abercrombie, considering he has these 3 cases against her. So that is the purpose of bond, and I believe we've made a point to every AL factor.
All right, I would agree with the state, Attorney McLeod. I don't see him getting out and helping you to investigate, honestly. But I'm not going to lower his bond at all. I'll leave it at the 30,000, 10,000 on each case as it exists.
Artist, did you want to say something? You know, you have the right to remain silent, but if you want to make a limited comment, I guess you can.
Yes, yes, I would. It's not nothing. It's just pertaining to my case. The cases, the allegations that upon me. This is the mother of my children. You can call her to this day, and she will tell you what's going on. Like she still get money on my phone, money on my book. So I don't understand how am I a risk to her. It's a relationship problem. When things got out of hand, nobody was harmed. I don't know where she get the punch in the face, dragged through the woods. It never happened. The car she said it was stolen. That car is in my mother's name. You can call my mother and you can get this factual.
I'm not here to have an evidentiary hearing.
Yeah, that's what I'm saying. But
I'm not going to go over all the every
that's-
charge and listen to that. That's for a different forum.
Yeah.
Um,
That's what I'm saying. Like, the mother of my children, you can call her. Judge. That's her.
well, the state will speak to the victim, and that will
Yeah, I don't know.
that will happen.
You know what I'm saying? Apparently, Miss Tucker must have reached out to her. She's just going off the record because she could have reached out to her. Because she would have reached out to her, the mother of my children, she would have told her, like, yes, I need him to be free. Like, yes, I would like him to be free. Like, she would have told her. So I don't know why Miss Tucker saying things to me. Like, it just, like, called the police off emotions because of a relationship problem. That's how it was. But she still, to this day, hit money on my book, hit money on my phone. City business, like see my children still to this day. The apartment that I got arrested, that's my apartment. She stay with me. My son, I'm a single father for my son. His mother just left him, so I had to go through defects and all this with my son. Carrying me to stand with my mother. Like it's a lot I got going on. I don't understand why you trying to frame me as a bad
Yeah,
person.
you do have a lot going on because you have a lot of cases, and they're all within the last 2 years. So
Like,
I will leave the bond where it is, and we have to move on. Thank you.
Your
All right, thank you.
I do also have two other clients, Your Honor, and all of them are going to be issues regarding their bonds.
Okay.
We get them 18 and 19, Mr. Grant.
So, Ms.
Okay.
McLeod, are we just gonna reset his case for trial further notice?
Yes, I've already waived arraignment in all of
Okay.
his cases. I'm waiting for discovery. I haven't received any yet,
Okay.
although I filed motion to discovery in all three of his cases. I would like him to be placed on the next available trial calendar.
All right, this is position 18, Jason Grant, 25 CR 0000582F, charged with 1 count of battery family violence, 2nd count of simple battery. And then position 19 is the FTA regarding that case. State.
Yes,
Or
Judge.
does he already have a preset bond and this is for modification or no? Where did Attorney McLeod go? I thought, was this her case?
Yes.
Uh-oh, she may have, there she goes. Okay.
Sit.
Oh, your camera went out and I thought we lost you.
No, I'm here, Your Honor. Did
Okay.
you not hear the gentleman's name?
His name is Jason Grant.
Is he my client?
I don't know.
Ms. McLeod, I sent out another one to see if you can assist, and you responded to
Oh.
one, but you didn't respond to this one, so.
Okay, I did not see this one. Okay.
Yeah, I sent it out after I sent the other one on the other
Oh,
gentleman, and I
Mr.
said, can you
Vargas,
assist with this
because,
one? Yeah.
okay, because I have spoken to Mr. Vargas. Can I get a moment to speak to Mr. Grant then? Because I
Okay.
haven't spoken to him.
Okay.
Vargas next, that's fine. We do Mr. Vargas next, number, to 44.
Okay, Mr. Vargas. Okay.
Good morning, Your Honor.
Good morning. Let's see.
We would like to get Mr. Vargas' bond modified.
Okay, 26 CR 001410G. Mr. Vargas is charged of 1 count of fleeing or attempting to elude, failure to obey signs and control devices, driving improperly or erratic lane change on position 44. All right. What is the current bond state?
The current bond is $2,000 good bond.
Okay.
But that's only on, fail to obey a single traffic and driving and property. He doesn't have a bond on the fleet to attempt to elude that was reduced to, from a felony to a state, so he doesn't have a bond on the flee and to attempt.
Okay.
We need a bond set on that, you know.
So
Yes,
the others are 1,000 each on the failure to obey signs and the driving
That's
improper.
correct.
Okay, gotcha.
and I would be fine leaving the bond at 2,000, maybe amend 500 and 500 and then 1,000 on the fleeing. But he does have multiple traffic offenses. He does have a hit and run in November 2025 that's still pending. And that is in felony court because it's paired with a felony terroristic threats. He has another fleeing from 2025, November of 2025. He's got a DUI August of 2025. So most of his 8 or 6 cycles are driving offenses. So, I would ask no lower than 2,000 total, 1,000 on the fleeing, 500 on each of the other charges, and a condition no driving unless he's got a valid license, valid registration, valid insurance, and to follow all the rules of the road.
Let me speak back to my client and then I'll let you know if we're okay with what you're saying, okay? So that would be, his bond would remain at 2,000, but it would also include the charge that he did not previously have a bond on, correct?
Correct.
Okay, well, let me speak to him and see how he feels about that. I don't want you to speak until you talk to me, Mr. Vargas. Okay?
All right.
So I'm going to call to speak to you.
And do we have other cases, Mr. Haddad, that we can do?
Your Honor, the only other plea that I have left is position number 47, Nicholas Wiggins. It's a time served sentence as well, Judge.
Yeah,
Okay.
he went downtown as well.
Oh, no.
Oh, boy. Okay.
Wait, Your Honor, can we, is it possible to add him on a Tuesday calendar? Only because he's getting time served, Judge. I know normally we like to keep it, Thursday to Thursday or Tuesday to Tuesday, but, and again, I don't know, Ms. Lewis would know if we're able to, since, I don't know how
Mhm.
the calendar is on Tuesday, Judge.
Yeah, Ms. Lewis?
Yeah, I can do an add-on, that's fine.
All right,
Okay.
Thank you, Judge. Ms. Lewis, thank you so much.
Mhm.
All right.
And that's for position what?
That's position number 47.
Is that Wiggins?
Okay.
Your Honor, that's all the pleas that I have. I will remain in the background, assuming the 11 o'clock folks show up for the bench warrant set aside. But I'm here, Judge. I'm just going to
Okay.
mute myself and remove myself.
If
Right,
you have their
thank
phone
you.
number, you can probably call them early. I don't know if you have their information, try to see if you can get them on
Oh,
early.
that'd be great if you don't, if you can
Um,
put in the chat or
Ms. Strong, and she can assist you with that.
Just give me a moment, Mr. Haddad. I'll put it in
Alright.
check for you.
Wonderful. Thank you. And I'll take care of
Alright.
that, Judge.
Okay, thank you.
Attorney Tucker.
Mhm.
On that order for the consent bond order, can you make sure that it shows the FTA number? Because I know it was reduced from a misdemeanor, from a felony to a misdemeanor because he was being held on a pretrial FTA.
Yes, I'll make sure.
Yeah, please make sure you have those numbers in there because they haven't updated his booking screen to show that the FTA was amended to a misdemeanor, so it shows felony. So we don't. You have to put all that PI and all those numbers on there to indicate that it was reduced.
Okay.
Because we don't have the case. This case number is not associated to his booking screen that we have the FTA with. So I just want to make sure all the thing is clear. Cover.
Yes.
So I was able to speak with Mr. Vargas, and he's okay with the $2,000 overall bond.
So we need to break it down. Judge, you're on mute if you're talking. We can't hear you.
Okay, sorry about that. Therefore, let me repeat that. I said for Mr. Vargas, position 44, we will enter now I don't know, is this a consent bond or just, I will do a bond modification. I don't know that it matters if it's by consent or not. But the first charge for fleeing will be a $1,000 good bond, and failure to obey signs, $500 good bond, and driving improper lane change, $500 good bond, for a total of $2,000. So I think this is
Your
just
Honor.
going in as a modification, correct?
That is correct, Your Honor.
Okay. All right, and that's it for Mr. Vargas.
Yes, I was also able to speak with Mr. Grant.
Okay.
Yes.
He's coming up.
Mhm.
And Mr. Grant is position 18 and 19 is the FTA. But that would
Yes, Your Honor.
25 CR 00582F, one count of battery, family violence, second count of simple battery.
Yes, Your Honor. I was wondering if the court would be inclined to give him a signature bond on the failure to appear, but because I believe he has a bond on the other charge.
Correct. He's got a $2,000 bond on the failure to appear. But I would object to any amendment. He's yes. So this is a very serious case. It's a battery family violence against his wife. They were arguing about him not making money, and he got upset with this and grabbed her by her arms, pulled her down till she fell, left an abrasion on her forehead, and he got a signature bond. He already got the benefit of a signature bond in this case, and he chose not to show up for plea and arraignment. So, based on the flight risk there, we would ask that the bond remain as set. That's $2,000 good on the failure to appear.
I
All right.
think it wasn't a situation that he didn't get notice. It wasn't like he decided he was just not going to show up. I do not believe he's a flight risk.
How many cycles does he have, ASG Tucker?
Yes, 1 second. So I don't see a return notice or anything in his case file that he indicating that he did not receive notice. Let me go to his history now. He has 8 total cycles. Another simple battery, family violence in 2018, a failure to appear in 2018, disorderly conduct 2020, misdemeanor marijuana 2020, this case, and then the failure to appear. So this is not his first failure to appear.
All right. So he should have been keeping up with someone, or some of them called down to the clerk or somewhere to get their court dates and to know. I am not inclined to give him a signature bond on his FTA based on his history and likelihood of returning. I don't know. I don't feel comfortable that I'm convinced he will do that right now. I know that 2018 seems far away, but I don't know what has been going on in between. He had another disorderly in 2020 and then this case. So I am not inclined to revise his or modify his bond rather. So I'm going to keep it where it is.
Your Honor, I will be filing a waiver of arraignment on his behalf and request that this case be placed on the earliest available trial calendar.
All right. Thank you.
You're welcome. I also have Mr. Price.
Okay.
What position number is that?
I'll have to check.
Oh, okay. It's
Like it's 34.
or 31 through 34, I think.
Oh, let's see.
He's got 4 total cases.
Yes. This is their Darius Price.
Yes, Your Honor.
Position 31, 25 CR 003-188L, one count of simple battery. Position 32 is 25 CR. Oh, let's see. 25 CR 00744L, charge of one count of simple battery, family violence. Position 33, 26 CR 001013L, one count of battery, family violence. And position 34, 26 CR 00128 one count of theft by shoplifting. So he has bonds on all of these cases so far.
Let me
Yes.
check.
I believe he has cash bonds, which he is not in a position to pay.
Okay. Let's see what we have state.
Yes, he has a $5,000 cash bond on the battery family violence, and I believe that's the only thing that's holding him. He does have, I mean, all three of these open family violence cases are against the same victim. The oldest one, I believe, one moment. The violence is getting worse in each case. In the first case, sorry, I'm clicking around. Okay, in the first case, he pushed her. In the second case, he spit on her. And then in that most recent case, the one that he has the $5,000 cash bond, he hit her in the eye, popping a blood vessel. So the violence against the same victim, Bianca Kelly, is getting worse and worse and worse. And then his history, he's got 30 total cycles. And most recently, he has, of course, these 4 pending cases. So not only is he continuously hitting and hurting and pushing and spitting on this victim, but it's also theft by shoplifting. So the most recent cases are these 4 cases. He also has an aggravated assault conviction from 2023 out of DeKalb County, along with a felony terroristic threats, same case. He's got a failure to appear in 2023, another failure to appear in 2023, another theft by shoplifting conviction in 2023, probation violation 2021 in Cobb, and another battery family violence in 2020. That's as far back as I'm going to go because the violence is increasing. So he's a danger to this victim, Bianca Kelly, as well as his history. I believe he's a high risk of reoffense. I mean, the fact he's got 4 open cases at all. So I believe a $5,000 cash bond is very reasonable in this case.
Okay.
Your Honor, I understand that my client and Miss Kelly are married and they share some children. What I'm asking for, Your Honor, is a surety bond as opposed to a cash bond. He's definitely not in a position to pay a cash bond. And he's been in jail for quite some time.
And just a little bit of history on the bonds. He did bond out on the simple battery. He had a $2,500 good bond, and that obviously wasn't enough for him to not reoffend. He had a $4,000 surety bond on the first simple battery. He had a $2,500 surety bond on the second simple battery, and those were not high enough. So I believe the 5,000 cash should stand.
All right. So position 31, the current bond is it a 4,000 surety?
Yes.
All right, and I will leave that the same. Position 32 on the simple battery, that's a $2,500 good bond.
Correct.
Leave that the same. And position 33, the 5,000 cash bond. And then what is the bond on position 34? I think that's what I missed.
Yes, I'm not sure that I
Theft
see
by
it on.
shoplifting.
Yes, let me double check.
Okay.
So I'm not seeing a bond on the theft by shoplifting. As you heard in the history, he does have a prior, so we would ask for a 1,500 cash bond, or excuse me, 15,000 good bond on the theft by shoplifting.
1,500.
Yes, yes, I'm sorry.
Okay. All right. So we'll set Ms. Lewis for position 33. I'm gonna leave it at the 5,000
Judge.
cash,
Judge, just
and then 34 the 1,500 surety.
that theft by shoplifting apparently was on a expedite accusation calendar. I don't know, it was reset from February 25th to 2026, and then it got on a SAP counter for today. That charge is not holding him in jail. Only charge holding him in jail is that battery, family violence with the cash bond. All the other charges are not associated with his booking screen that he had already posted bond on those charges.
Oh, okay.
So only one we
But
really
base-
need to address is the
The
battery, family
5,000
violence
cash.
case.
Okay. All right. Well, I will leave that at the $5,000 cash based on the history and the allegations. He's got FTAs, probation violations. So I want the victim and society to be safe. So I'm going to leave it at the 5,000 cash. And
Thank you.
anything else? Right. Anything else?
Nothing else. That concludes my business before the court today. I would also like his cases to be placed on the next available trial calendar, Your Honor. I've already waived arraignment on his behalf.
All right.
in
Thank you.
those cases. You're welcome. That concludes my business before the court today. May I be excused?
Yes, you may. Thank you. See you next time.
Yes, ma'am.
I'm at number 4, Mr. Barnes.
Okay.
Good morning, Your Honor. This is going to be a negotiated plea. Myself and the prosecutor have discussed changing some of the terms.
All right. This is 26 CR 001358E Demetric Barnes, charged with 1 count of battery. State.
Yes, Judge. He's pleading guilty to battery with the terms 12 months to serve 26 days, credit for time served 13 days, balance probated, to complete 4 hours of anger management through Civics Academy, then 40 hours community service and no further contact with Jack Carr. So just that anger management term got altered.
Okay.
Does defense stipulate to ID, venue, and factual basis for the purpose of this plea?
Yes, we stipulate for purposes of the plea.
All right. All right. Mr. Barnes understands you wish to plead guilty. Is that correct?
Yes, ma'am.
Can you raise your right hand for me so I can swear you in? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? All right. And I'm going to ask you a series of questions to make sure you understand your plea. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
Oh, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Okay, speak up a little bit for me.
Yes,
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you do understand that if you're currently on probation, it could be affected by this guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
As to the charge of battery, how do you plead?
Guilty.
All right, I will accept your guilty plea. You understand your conditions, correct?
Yes, ma'am.
All right, thank you.
Thank you.
He also then remain on probation the whole entire time too?
Sounds like it, yes.
Okay.
Item number 9 and 10, Mr. Brantley.
Okay, and I didn't know, is Mr. Haddad, are we doing anything with,
Your Honor, just as an update on the Miss Gagnon or Gagnon,
uh-huh,
I left a voicemail. I happened to see that she's on Zoom and then she's no longer on Zoom. So hopefully I'll hear from her. I was able to reach the other, Corinne Rogers, and I asked him to log on, and I'm ready for that. As soon as he logs on, I'm ready for that.
okay, maybe by then is Miss Gagnon getting back on? Maybe she had a
I
bad
hope so,
connection.
Judge. Yes.
Okay, all right, let's hold for a second. Let me take this one and then see if we've got them both. So I
Thank you,
can
Judge.
knock them out at one time. Okay,
Thank you.
all right, this is position 9. Is it Ahmad Brantley?
Yes, Your Honor. For this case, we'd be asking if we could do a bond reduction.
All right, this is 25 CR 003327C. Mr. Brantley's charged with 2 counts of simple battery, family violence, 1 count of criminal trespass. And then position 10 is the FTA associated with that case. And what do we have already?
So he did get out already on the simple battery, criminal trespass, and simple battery. So it's just the FTA holding him. That's a $3,000 good bond on the FTA. And his history, he's just got 2 cycles, the simple battery and the failure to appear. So this case, though, is very serious. He should not have failed to appear on it. The facts of this case, there are 2 victims. Yes, okay, so he had been drinking heavily, and attacked his ex-girlfriend and her current boyfriend, Andrea Grant. So, just considering there was a big fight, there were 4 total witnesses, including the 2 victims. So just based on the fact that he failed to appear, I mean, 3,000 might be too high. The other FTAs have received 2,000, so I would be fine amending it to a $2,000 good bond. But I definitely believe it, by the nature of the FTA, it should be a good bond.
All right. Are you
Your
willing to accept that, counsel?
So my client tells me that the situation that happened is false, basically. He says that these people were his roommates. He lives in a rooming house, and that they have attacked him previously, and that they simply do not like him, Your Honor. So I'm not sure who's telling the truth here, but what I do know is that my client relates to me that the facts as alleged are not true and accurate, and that one of the alleged victims is not even his ex-girlfriend. They are simply roommates in a rooming house. He has nothing to do with them other than the fact that they are roommates in a rooming house, Your Honor. Further, my client tells me that he wouldn't be able to afford anything over $1,000 good bond, Your Honor. So I'd be asking, based on that if you could lower the bond to 1,000, that would be much appreciated.
All right, state.
No objection. I think $1,000 good bond is fair considering he doesn't have any past FTAs.
All right. All right, we will modify the bond on position 10 to 1,000 good bond.
Thank you, Your Honor.
All right, thank you.
Ms. Rainford, what are you doing with the position number 9? Are we waiving arraignment or?
Yes, sorry.
Thank you.
And this got 16-17, Mr. Gay.
Ms. Tucker, I just sent you another email relating to Mr. Gay. Not sure if you've received it yet.
I just received it. Okay, well, I'm not gonna null pros this case. We can go to trial.
Okay, let me speak with my client.
Okay, it is a diversion offer.
He's willing to do the diversion offer with the signature bond.
Okay, well, Judge, we have worked out a diversion offer. It's gonna be to complete the Family Violence Intervention Program, and then there is a $250 diversion enrollment fee. If you could send me his email and phone number, Miss Rainford, so that we can get him signed up as soon as we can, then I will consent to a signature bond. I believe it's just, let me see what he's got. Yes, it's a failure to appear. He's got 2 failure to appears.
My understanding that he never received the notices on those, and I told him that next time he needs to make sure that he's just keeping track of his case period and not wait for the notices.
Do you know which 2 cases they are on?
I need to go back into Odyssey to see.
Position we're talking about?
16 and 17, Mr. Gay.
Okay, this is his only open case, so they may both be for this case.
They are. He
Okay.
FTA in 2025, and then he posted bond before he got on the state all-purpose calendar for that 25 FTA 001034 FTA. So they're both associated with this case.
Okay, well then I would consent to a $2,000 signature bond on one and $3,000 signature bond on the other. Now, if he does not complete the terms of diversion, the case will go back on a trial calendar. And then, if he fails to appear again, the bond will be converted to a good bond. But with those terms in mind, the state would consent to that surety, good signature bond, excuse me.
All right.
Can I just say one correction on that 25 FTA? The bonding company surrendered him on that bond. So that's the reason why both of the FTAs are appearing on his booking screen So the bonding company surrendered him on the first round on the 25 CR, the 25 FTA 001034. They surrendered him on that. That's why 2 FTAs are showing for him on his booking screen. So technically, he does have a bond on the FTA, the second FTA. I mean, the first FTA, no more.
So it's on the second.
Yeah. So I mean, whatever y'all choose to do is fine.
So do we need to give him is it technically a third bond? Or just
What
leave the first FTA and
yeah.
just give him the bond on the second one?
It's kind of weird because see, this is 2 and 1, and see, since the other FTA, he just got the bond. The company just literally surrendered him on this bond on the first FTA, and then he was picked up on the second FTA, which is the one that has the $6,500 cash bond, and then the surety bond that was originally a $6,000 surety bond. They surrender him on it. So really, one needs to go away. Me personally, one needs to go away because he did post bond on it, but the bonding company found out that he was in there and they surrendered it, the bond on there. So that one he was scheduled on the SAP calendar, but he was already bonded out before they could address the FTA the first go around. And then he missed court again. And then that's what we are up against right now on the one on the calendar.
All right, state.
I would go with my original recommendation, just amend the 2 bonds, 2,000 on the first FTA and 3,000 on the second FTA, both signature bonds.
Can we do it that way, Ms. Lewis?
Yeah, as long as the order reads what it says and it covers the correct FT numbers associated with them on his booking screen, so the jail won't be confused.
Right. That's what I was kind of thinking, but
Right. And I've got the original FTA is 25 FTA 001034. And then the second one's on this calendar.
Yeah, correct. So the 25 FTA 001304 is the one that the bonding company surrendered him on. So that information will have to be on the order.
okay.
Whoever producing the order. And also, if you can, I don't know who's going to do the order, also indicate the original FTA number, because that's what the jail has for the first FTA is 23-002386 FTA. Again, that's 23-002386 FTA. Make sure that number is also associated on that amended bond order for the first FTA.
Okay. All right, if we're all clear with that, then ASG Tucker, are you doing the orders?
Typically the PDs do them.
Oh, okay. Miss Rainford.
Yes, I'll handle the orders, Your Honor.
Okay. All right, that's it for Mr. Gay. Let's see, do we have our other two? And is that it for the calendar? Everyone on the SAP calendar?
I'm combing over it right now, Judge.
Okay.
I think I'm pretty sure it is. I'll have announcements
Yeah,
on a
make
couple other
sure.
ones that I'm missing,
Okay.
so I think
Okay.
they're all Miss Rainford cases that I need some announcements on.
Okay.
And ESG Tucker, I just want to make it clear again, so on the position 17 is a $2,000 surety, and the original one is a $3,000 surety, right?
Reverse.
Okay, the first one is 3,000 surety, and the other one's 2,000, right?
The older one is 2000 signature.
Okay, signature.
Yes,
Okay.
they're both signature bonds because he's going to enter the diversion program
Okay, signature bond through pretrial or just a signature bond through SOB through the jail?
through the jail is fine.
Okay. Okay. I just want to make sure that I had that correct. Thank you.
Mhm.
Mr. Haddad, somebody just logged on with the iPad. I'm not sure if that's one of the people that you spoke with or not.
Yeah, I'm not sure. There's also a Zoom user. Yeah, all right. So one of them just identified herself, Judge, the iPad. I'm ready on that. I was able to speak to her.
Okay.
And if the court wants to inquire about the Zoom user, whether it's Mr. Rogers or not, I can ask, Judge.
Right. Let's see who they are.
Mr. Rogers, are you on Zoom? Well, I'm not sure who the Zoom user is, Judge, but we can start with Ms. Gagnon if the court wishes.
Yes, I need to have that other Zoom user. Is that an employee or whoever it is? Please identify yourself. Usually in the employees will say who they are. Unless someone is on two devices, I'm not sure.
I removed them, and if they come back in, we'll address them then.
Oh,
Since
you've put them out. Okay.
I did
Okay,
because I
good.
asked them to unmute and they didn't unmute.
And they
either.
didn't. Okay. All right. Thank you. All right. I'm going to call the DV bench warrant calendar. First case is 25 CR 008304B. Sarah, is it Gagnon?
Yes, Your Honor.
Okay. Charge at 1 count of simple battery, family violence.
And Your Honor, on behalf of Ms. Gagnon, I spoke to her earlier, and the situation with her, Judge, is that the notice has been going to the residence where she used to live at, which is the incident, and she's got to stay away. She does not have a stable address, but she has been reporting to pretrial services. She had been she took up to 3 classes of anger management as required by the bond order, the initial bond order. And she had been in contact with pretrial services, and then she found out that there was an outstanding warrant for missing court. So she immediately went to the courthouse and and is now here, Judge. She had provided the clerk's office with her email address because the issue is she does not have, she's been moving from one place to another, like different hotels, motels, and the best way for her is A, by email, but B, also with pretrial services, which she had been reporting. So under these circumstances, Judge, I would ask the court to set aside the bench warrant. And I can assume that's acceptable. I can, of course, prepare the order, but also just remind the defendant that to make sure that log on and make sure that this doesn't happen again, because until she's got a stable address, the notices are not going to be. She's not going to be able to receive the written notice, Judge.
Isn't there, I thought there was the church or location where I've been hearing, I guess, on some of the other calendars where persons are able to use that location to get their mail.
And
I don't know if you're familiar with it.
yeah, I
or-
am, Judge, but usually those are, more of the clients that have like a homeless shelter challenges,
Oh,
which
okay.
Miss Gagnon was employed. She lost one job, but she's still employed. So she's, unlike
May not
many of my
qualify
other
for that.
clients, she doesn't fall into that category, Judge.
Right, gotcha. Okay. And no friends or anybody probably willing to let them use the address. As long as she can keep her internet going financially, I guess, to see the emails. But I am a little concerned, with no mailing address, because they do, mail the notices, and how the internet is, or Wi-Fi or whatever. Sometimes it doesn't go through, or it accidentally goes into the spam, and then you don't see it. So I was just trying to see if she has a backup way. Yes, ma'am.
Your Honor, when I had went in to try and clear the warrant on Prior Street, prior to that, I went in for the actual restraining order. And when I told them that I didn't have, I'm so sorry. When I told them that I didn't have a residence, they told me to put down my email address. And I was able to get in contact with my pretrial officer as well as my officer for the anger management courses via email. But I'm so sorry. I was never able to receive any correspondence regarding any court dates. And then I went up to the courthouse as well. And when I went up there to clear the warrant, they said that they didn't have my email in the system, but I put my email down. I'm very attentive to my email. I check my email for everything. And so I want to stay compliant with everything. With my anger management, I don't necessarily think that's the problem. I just lost my mom. And so I asked for some grief counseling as well. And so we were going to start some grief counseling and stuff, but then everything got put on pause, Your Honor, because of the warrant. And so I was hoping, I'm not sure how today is going to end, but I was hoping that at least I can be put back on for the anger management so I can get the grief counseling.
Right. I do understand. And Miss Lewis, we don't, and I say we, meaning the state court, we have to mail. We don't do emails.
Well, yes, they do. We do
Oh, they
email
do.
now, but she has to indicate it when this is Judge Porter's case. So she's
Uh-huh.
got to contact her litigation manager, Ms. Smith, and let her know of her address situation so she can find out when her next court date will be. If Ms. Smith be willing to notify her by email, she can make that notification, but she will have to contact Judge Porter's litigation manager. She can email her directly. I can give her email address, and she can
Okay.
in the chat, and she can contact Ms. Smith and let her know. And Ms. Smith probably can respond back to her and let her know exactly what her next court date will be.
Right. Okay.
So I will put that in the chat directly to
Okay.
her.
All right. So you're clear on that, Ms. Gagnon? Go ahead.
Yes, Your Honor. What would be the contact information for Judge Smith or Miss Smith? How would I get in contact?
She's gonna put that in the chat to you. You see the chat feature there?
And
Yes, ma'am.
Ms. Gagnon, if you can put your email address as well to me, I'll follow up with Judge Borders Chambers to ensure that that there's open communication. At the very least, our office can be involved to make sure that you're aware of your court date.
Thank
Well,
you.
I appreciate
Yes,
you
sir.
being responsible to handle it and trying to be as aware as you can. I know it's a difficult time for you. And state, is there any objection? I'm going to not issue or retract on the FTA warrant and allow her to get her email to as many people as possible that need to know and need to have it so that she will keep up with her court date. And she's been reporting to pretrial, things of that nature. And, I don't know, again, with the original facts of the case, but certainly needing grief counseling. And if you don't get it, it comes out in other ways. So hopefully you will be able to find the proper counseling. I'm not for sure that anger management is appropriate, but that may be all that's offered just to, again, get you through this matter.
Thank you, Your Honor.
Okay.
Will I be able to resume everything now that the warrant is going away? Will I be able to contact my pretrial officer, Turnbow? Okay.
Yes. Yeah.
Yes, ma'am. Thank you.
Ms. Gagnon, don't forget to include your email address to me.
Yes, sir. I can just put it in the chat.
That'd be fine, ma'am.
Yes.
Thank you.
And Your Honor, once she completes that, can she be excused, Judge?
Yes. And she's free to go.
All right.
Thank you, Your Honor. Have a great week.
All right. You're welcome. Good luck to you.
Thank you.
Mhm. Did you get the information from Miss Lewis?
No, I put my email in the chat, but
Well, hang on a second.
Oh.
Just mute yourself. She's doing probably 20 things right now. Give her a
No,
second.
I gave it to her. She just had to check. I just emailed it to her.
Oh, she just sent it. Oh, she emailed it to you. Let's see.
I mean, not emailed to her. I mean, I did in the chat. The
Okay.
information.
Look and see if you have a chat from Miss Lewis.
She should. It's directly to her. Do you see
Yes.
it, ma'am?
Yes, sir. Yes, ma'am. I got it.
Okay.
Thank you so much.
You're welcome.
Okay. All right. Good luck to you. Thank you.
And our other bench warrant defendants on the line too, Mr. Rogers.
Okay. This is 23 CR 006729F Corrine Rogers, charged with 1 count of battery family violence, 2nd count criminal trespass, and damage to property.
Your Honor, I did speak to Mr. Rogers. Judge, I tried to look on Odyssey. I confirmed his address is the correct address. But I tried to see in Odyssey where the notices have been sent because he informed me he had not received any notice. And as soon as he found out about the bench warrant, he contacted the clerk's office, and that's why he's here. But he is working, Judge. He works in landscaping. He lives with his mom at what appears to be the right address. So I would just ask, under these circumstances, I'm not really sure if notices are being sent because I can't confirm where they're being sent if they've been sent to. So, but the address on file is his correct address, Judge.
The notices were sent to 1361 Westbourne Drive Southwest. Is that correct?
Yes.
Yeah, that's where all his notices went to. Zip code 30310.
Yes.
Yeah.
That's
And-
what, and that's a house?
Yes.
Okay. Yeah, those are the notices were sent to.
And Ms. Lewis, the last notice, what date was that? Because it doesn't look like I can't see it on Odyssey.
Looking at the notice history from the Odyssey from Judge Richardson's case manager, from her February the 2nd, 2026 calendar. I guess that was the calendar that he missed. And
Okay,
said that
all
he
right.
needed to be arranged, so that she sent these out, they were generated in January the 13th of 2026.
I see that. Thank you. Thank you. I
Mhm.
missed it earlier. Thank you.
Mhm.
Your Honor, I mean, you know, I don't know how to explain it, Judge, other than the fact that Mr. Rogers is, as soon as he found out about the warrant, he reached out to the clerk's office. You know, I think he has to have additional burden of himself checking because clearly, uh, since notice or the records show that notices have been sent and he has not received them, um, you know, I think it's imperative on him to regularly, almost like daily, to check when his next court date is, because otherwise he's gonna, you know, end up and right back to where he is right now.
And Judge, we would object to lifting the bench warrant. I believe the bench warrant it has been issued, and I believe it needs to be he needs to be arrested until trial. Based on his history, he's got a 2017 battery family violence that was null prost, a 2020 battery family violence conviction in 22 SC 185405, a 2022 battery family violence conviction in 22 CR 000815F, and a 2023 battery family violence First Offender Act in 23 SC 185624. He's got an additional battery family violence from July 2025 out of DeKalb County that I don't know. I do not know what happened in that case. We did request a DA transfer based on the priors, but they denied it. But this case was set for trial. I actually worked it up. That's why I'm so familiar with it. And we had an officer subpoenaed, and victim Charity Jones was personally served. So, you know, our investigators are, you know, taking the risk, going out on the streets and personally serving these people. So he's failed to appear on a plea and arraignment calendar. He failed to appear at the trial calendar. And we just learned that all of these notices went to his correct address. So I would ask that the bench warrant remain issued and
I
that
haven't
he is held
received any
in
notice.
jail until the
Hold
trial.
on. Do not talk, Mr. Rogers. Don't interrupt. All right. What was the last thing you said, ASG Tucker?
Just that I would ask that the bench warrant stay as issued and that he's arrested until he can tell trial.
All right. Mr. PD Haddad.
Your Honor, if I may inquire, did Judge Richardson issue a bond? I mean, normally a bond is attached whenever there's a bench warrant. I just want to be clear that, I mean, he's entitled to a bond. It's a misdemeanor, but just want to make sure that it has been filed, because if it has not, and the court is not going to set aside the bench warrant, that we need to make sure that he, you know, there's a bond amount that's in the system, Judge. I don't have anything else to add other than what I just told you, Judge, as far as the setting aside the bench warrant.
So a bond on the battery family violence.
Yeah,
So
there's a bond set for the FTA. It's an $8,000 surety bond.
Thank
Okay.
you. That's really all I was trying to inquire as far
Yeah,
as that.
she said, yeah, the judge said an $8,000 surety bond on this FTA.
Thank you, Ms. Lewis.
Mhm.
All right. And the state is not inclined to agree to drop it. And I see where he's had an FTA in 2020, well, this one rather, but he's had one in 2024 and another one in February of 2026. Is that correct, State?
yes, Judge.
And I don't know, Mr. Rogers, why we can't get you back to court.
I was arrested for this case like 4 months ago. I was arrested in July for this same case in FT. I settled it when I went to court. Well, I was thinking I settled it, but when I just found out about this warrant 2 weeks ago, it was misdemeanor. But the felony cases I took probation for. So I'm knowing this case is still, but I'm thinking I settled this case. I really didn't even know it was a still misdemeanor case open. But even when I was locked up the first time, they said the court date got to my mom's mailbox after the actual court date. They were saying that they court system or mail system bagged up, and people getting their mail late. They saying the court date was February 2nd. I haven't even received the court date in my mailbox yet. Saying it.
And you haven't changed addresses, is that correct?
No.
Let's look at it a little bit here.
I even just want to get my ID updated with the same address on it.
Well, we wouldn't know about that unless you tell us. And I understand you know, people think when they change their driver's license or things of that nature that we find out about it. We don't unless you tell us. You have to let us know.
I never changed the address.
Judge, so it looks like the FTA, when he failed to appear in 2024 for this case, was set aside. So he must have reached out or done something in 2024, which put him on notice that he needs to be looking out for these notices, that he needs to be, you know, updating his address. So I believe that this failure to appear from 2026 should stand and should be valid.
All right. Have anything else to add, PD Haddad?
No, Your Honor.
You know, you have this is your second FTA in a very short period. Are you working or anything?
Yes.
Where do you work?
Hummingbird Landscaping.
Is that your company or someone else's?
No, someone else.
I'm sorry?
No, someone else's.
Oh, okay.
Do labor.
How long have you been working there?
Since 2018.
Long time.
Yes.
And we don't have any return mail. I'm asking that question, or would we not know unless it came back? Because it said it was Judge Richardson.
Correct. When the notice is returned, it's typically uploaded into Odyssey. I don't see any returned mail. And I do see from that first FTA, the defendant signed a paper on January 29th, 2025. He signed that he would be present at all scheduled court hearings, and he gave this correct address.
So there shouldn't be a reason why he didn't get it.
Correct.
Well, I will give you one last chance, Mr. Rogers, to set aside this bench warrant. Otherwise, I really kind of agree with the state in the sense of having you to turn yourself in. But this will be the last. Can't miss again, and you've got to keep up by calling or having an email attached to the information, like we just told the other young lady.
Okay.
So you have an email that you use regularly and check?
Yes.
Okay. So again, Ms. Lewis, I guess he needs to contact Judge Richardson's litigation manager.
Yeah, he can contact Mrs. Daniels. You can email her, and to verify, his next court date, if he needs to know for certain, the actual date. I'm pretty sure she probably would know what the scheduled date is based on their calendar. If he wants a direct, answer.
Right. And that's what you need to do. Cause my gut was telling me to go ahead and revoke you, but I'll give you this one last chance.
I would really appreciate it. Could someone put the number down in the chat that I got a call?
It's
And
best that
my
you
case number.
It's best that you email her. It's best that you email her.
You can
I'll put
put
her
it in the
email.
chat.
I'll put her email directly to you in the chat right now.
Thank you.
Does Mr. Rogers have the number to the clerk's office? I'm sorry if I missed it, so that he can call every 30 days to check on his court date, since he is saying that he's not getting notices in the mail.
Right. Do you need that number too, Mr. Rogers? That's what you need to do.
Yes.
Okay. You can repeat it, Ms. Strong.
It's 404. Do you have a pen, Mr. Rogers? Or you want me to put it in chat?
Can you put it in the chat? You can say it. I was gonna save it in my contact.
I'm about to put it in chat.
All right.
Okay.
And then yeah, save it in your contacts.
I have it.
Okay. All right. Anything else? You have everything you need, Mr. Rogers?
Yes, ma'am. I had an email and the phone number.
Okay. All right. Get on that immediately.
Thank you. I'm doing it right now.
All right.
Thank you,
Take
Judge,
care.
and
Thank you. Mm-hmm.
I'm sorry, Judge. I will email both orders to Ms. Lewis for the court's review and signature, of course.
All right. All right. That will conclude this matter. Good luck to you, Mr. Rogers.
I guess we briefly can go over the calendar because there's a couple of things I don't have announcements on.
Okay.
If y'all ready to do that.
Yeah.
I'm waiting for Miss Rainford. Is she in the courtroom?
There she goes.
Okay. I guess she could make the announcement because I am missing a couple of announcements.
Good morning, everybody. I've got a couple of cases. Good morning, Judge.
Good morning. How are you?
Okay, Mr. Bartel, I think you probably some of those I need announcements on.
Okay.
I'm sure that's the case.
Right.
Okay, so I'll go over the counter and then y'all can make your announcements for the ones that I'm missing, okay?
Okay.
Position number 1, waive arraignment. We set for trial further notice. That's 1, 2, and 3. Position number 4 took a plea. Position number 5, 6, 7, and 8 was released. We set further notice. Position number 9, waive arraignment. We set for trial further notice. Position number 10, modified the bond to $1,000 good bond, and this should be set further notice. Position number 11, 12, and 13 were released. We set further notice. Positions 14, I received a waiver for arraignment. We set further notice. Position 15, same announcement. Position 16 is reset for diversion, further notice. Position 17, the bond was modified to a $3,000 SOB through the jail, and also amended his first FTA of 23-002386 to a $2,000 SOB through the jail. And that's reset further notice. Position 18, waive arraignment, reset for trial further notice. Same announcement for 19. Position 20, release. Position 21 was released. We set further notice along with position 22, 23, 24. All were released. We set further notice. I did receive a waiver arraignment for position 25 along with 26. Wait for jury trial, further notice. I did receive the transfers for position 27 and 28 to Superior Court. Position 29, I have announcement that those cases need to be reset to a compliance counter. Mr. Bartell, will that be 319? Will be great for you next Thursday.
And I'm sorry, I meant competency. I may have put compliance, but I meant competency.
Oh, competency counter. I'm sorry.
Which number is that?
Never mind. I got it's competency counter. I'm sorry. We set for the competency counter for 319. That's going to be next week. Same announcement for 30. Position 31, 32, 33, and 34. All waive arraignment. We set for trial further notice. Position 35 and 36. I have announcement waiver arraignment. We set for trial further notice. Is that correct?
That is correct, Ms. Lewis. I'll send you both notices. The calendar does not show the 26 CR case.
I know.
But the offer does. So
yeah. I did an add-on just in case he ended up taking a plea or something on that case. But yeah, it was added on after the fact. And plus the case number is 26 CR 1486F, not 24.
Right, I got that. Thank you.
Okay. Position 37 and 38 is reset further notice. Defendant was released. What's the announcement on 39?
39 is my case. We have an offer from the state. Mr. Smith indicated that he did want to enter a plea. I was advised by the deputies that he was brought downtown, so apparently he's not available. I don't know why he was brought downtown, but he does have a felony holding him in with no bond. So I think if the case is reset for a week, that would not prejudice.
Okay, so you want it reset to next Thursday, the 19th?
Yes, ma'am.
Okay. Position 40, defendant was released. We set further notice. Position 41, what's the announcement on Strong?
That's the same announcement. We have not been able to communicate the plea offer. She was in a medical appointment yesterday when I went to see her, but she has a felony holding her in with no bond. And we would just ask for a 1-week reset. We do have a plea offer.
Okay, that'd be 319.
Yes, ma'am. Thank you.
Position 42 was a plea. Position 43 has an amended consent bond order for the FTA to a $2,000 surety. That was an FTA for 3 pretrial services. Just want to let you know. Position 44 is reset further notice, wait for trial, amended bond order to a $2,000 surety. They modified the fee to Alu, $1,000 good bond, failed to obey single control device, a $500 good bond, and driving improper erratical lane changes, a $500 good bond, which totals a $2,000 surety. Position 45 and 46. 45 was a plea, 46 was null pros, and 47 is going to be added on to Tuesday SAP counter as an add-on. That would be 317s. Any corrections? And both of the bench warrants were set aside. And I guess we can go into the competency calendar.
Thank you. Your Honor, may I be excused?
Yes, you may. Thank you. See you
All right,
next
thank you.
time.
Thank you,
All
Ms.
right.
Lewis. Ms. Tucker, thank you.
You're welcome.
And on the competency calendar, Your Honor, we have one plea with Mr. Vanis, who's here today, and possibly another one with Ms. Holloway, but she is at ACBC, and I need to talk to her to let her know what the state's offer is. So if we could have a brief recess so I can do that, I think we'd be ready after that.
Okay, sounds good.
What was
Thank
the possible pleas on Mr. Bartel?
It's Mr. Vanis and Ms.
Number
Holloway.
7, 2 and 7.
2 and 7, okay.
Yes, ma'am. All right, thank you.
Okay,
And I
Ms.
guess
you
the
have
court
a
reporter will
moment?
stay on until we get done with those.
get those 2 pleas right.
Mhm.
Miss Lewis, when you have a moment, I sent you an email.
Yeah, I was trying to look it up and verify it, but I was juggling here. I saw it. Give me a minute.
No worries, just when you have a moment and I'll
Yeah,
get.
get it and I'll clarify it for you.
Thank you.
You're welcome.
I'll be right here, Katrina.
Thank you. Thank you, Ms. Carter.
You want? My own. You want? My own.
Yeah, Your Honor, I think we can proceed. I still haven't had a chance to talk to Ms. Holloway, but she's at ACDC, and
Okay.
I don't see them on the screen. We have a plea offer from the state. It's time served, but she has a felony holding her in. So if we have to
Okay.
move her to next week, it won't prejudice her.
Okay.
I think we can probably go ahead with the rest of the calendar.
Okay.
Oh, Your Honor, I've been informed ACDC is right on the phone, so I'll talk to them now.
Okay. Okay, we'll hold a second again.
Yes, Judge, I was advised by Ms. Milton that she's going to go get Ms. Holloway. So I think she'll be on the screen before too long. I think we can go ahead with Mr. Vanis's plea, if you want. Go ahead, Vanis.
All right, this is 26 CR 0000647E Jesse Vanish, charge of one count of criminal trespass. State, what's the offer?
Yes, Judge, he's pleading guilty to criminal trespass with the terms 12 months to serve 82 days, credit for time served 41 days, balance probated, to complete an MHET, and to stay away from MARTA. And he does have a permanent ban from MARTA.
And that is the agreement, Your
Okay. All right. Do you still stipulate?
Honor. We do stipulate to the three factors for a plea.
All right. And is it Mr. Vanis?
Yeah.
I understand that you wish to plead guilty. Is that correct?
Yes.
All right. I'm going to swear you in first and then ask you a series of questions for the plea. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. And speak up a little bit so my court reporter can hear you, and put your hand down. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding right now?
Just medication.
Okay. Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And that you are prepared and agree to waive these rights today?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes. Yes. You did.
No. They've not enticed you to plead guilty with anything, right?
Yes. Y'all plead guilty.
Okay. And so, have they promised you anything just to get you to plead guilty?
Yeah, he said my time would be served today.
Right. So you understand the terms, but he's not promised you anything extra to make you plead guilty.
No, no.
Okay. All right. And you know that if you're on probation, it could be affected by your guilty plea here today.
Yes,
Okay. And so do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
yes, yes.
And as to the charge of criminal trespass, how do you plead?
Guilty.
All right. So you understand you cannot ever use MARTA, the bus or the train. You have a permanent ban. So you have to always take some other form of transportation, right?
Yes, yes.
Get arrested again if you go back.
Yeah.
Okay. So stay away forever from MARTA. Okay. All right. Good luck to you.
Thank you, Your
I'm
Honor.
getting out tonight.
Huh?
Getting out tonight.
As soon as they process you.
All right.
Mr. Bartel, the only condition he has is the MHET?
That's correct. Yes,
Okay, and that's through probation?
right.
Okay, and once he completes that with probation, he stays on it?
Yeah, we would ask you to go non-reporting once he completes the MHET.
And any conditions that they recommend.
Correct.
State have any objection to him going non-reporting once he's completed everything?
No objection.
Okay. All right. He'll go non-reporting.
Okay, thank you.
All right. Thank you. I think we're waiting on ACDC.
And, you know, I do have, I guess, a leftover announcement to make.
Okay.
Ms. Monique Larry, she was number 29 and 30 on the SAP. That is a reset to the competency calendar for next week, the 19th. But I did see her, and I believe she does need an evaluation.